Good afternoon and welcome to Navigating Parenting Time During the Holidays. It's a tips and tricks guide to preempting typical and COVID-19 specific visitation issues. My name is Caroline Davis. I'm a staff attorney here at Her Justice, and I appreciate you taking the time to watch today this guide to navigating parenting time, which, as we all know, can be one of the most difficult things to try and get through, especially during the holidays and especially with a global pandemic on our hands. So I am going to share my screen with you. So for today, our agenda is going to be first talking about client-centered planning, and then a little discussion of managing your client's expectations, a further discussion of negotiation with opposing counsel, or if there is no opposing counsel, the opposing party themselves, and then some common scenarios and issues to look out for through the use of some hypotheticals. And finally, a COVID-specific discussion of things that will be issues probably this year and hopefully not next year, but possibly, but things that might come up specific to the COVID-19 pandemic. And a little time at the end just for a brief discussion of any other issues that may come up. So first, client-centered planning. So as we all know, the clients that we are working with are low-income women living in New York City, and that should be at the forefront of your mind as you go into every conversation with your client. But specifically, when you are talking with your client about parenting time and visitation during the holidays, that should still be right there in the forefront. You're going to want to schedule a meeting or a phone call with your client as early in the season as possible. Usually, I try and do things early on in November so that you can do the whole holiday season in one fell swoop, save both you and your client a lot of time and difficulty in trying to schedule each individual holiday as they come. And also that will allow for a more peaceful transition for the client and opposing counsel and the opposing party as well, and the children, of course. It's really important when you're scheduling these things not to assume anything about the client, not to assume anything about their background or about what holidays they will and won't celebrate or what holidays will or will not be important to them. Every family has different holiday traditions and different things that may or may not mean anything to them. Just because you celebrate one holiday doesn't mean that's going to be the important holiday to your client. So it's important to go in asking questions instead of telling them things. Usually I try and start the conversation by just generally asking what holidays are meaningful to them and their family, what traditions they normally celebrate as a family. And clients will be very forthcoming about what the most important things are to them, what holidays mean the most, what they're willing to concede on, what they're not willing to concede on, if they really want the kids for some big family celebration on a particular day. And it's not always the same for everybody. So just don't go in assuming that there's going to be a particular holiday that means most. Discuss your client's work schedule and the children's vacation schedules. This year, obviously, is going to be really different than most other years because the children's vacation schedules don't really make that much of a difference because the children are generally home anyway. But, you know, some kids are in private schools that may be going to school, or they may be in religious schools that are actively in school. So don't assume anything about that either. The children may or may not have vacation, may not. So just make sure you lock down when the children are actually off from school and when they're not, including for this year. Also make sure that you know whether your client is working from home, working remotely, going to work, what their hours are, and how that might impact any visitation and parenting time, including pickups and drop-offs. And we'll talk a little bit more about that in the COVID specific realm, but generally, it's going to be important to make sure that, you know, your client schedule is carefully, you know, factored in when you're trying to make a parenting time schedule, as well as the other party's vacation schedule. If there's any way that they can take their vacation separately so that they can both have time with the children, that's ideal, but that doesn't always happen. Some people have a certain amount of PTO that they accrue before the end of the year. They need to take it at a certain time. So just know that there's a lot of factors that are going into this discussion. You're going to want to make sure that you discuss the best case scenario, the middle case scenario, and the worst case scenario. And this is more so that you have a full picture and understanding of what it is exactly that your client wants. Because they're going to tell you, and I can say from experience, they're going to say they don't really care that much. It's not that big of a deal. You know, we usually do it this way, but they're pretty open and they're pretty, you know, ready to compromise, and it's not going to be an issue. You know, they've done it before, it's going to be fine. It will be a big issue, and it's going to end up blowing up at some point, because what doesn't seem like it's a very difficult thing to navigate ends up with all these tiny nuanced things that can end up being, you know, the whole agreement can be, you know, dead in the water because of, you know, someone was 10 minutes late, or because, you know, we thought that the pickup and drop off was going to be one place, but it ended up being at a different place, or because somebody ended up having to be called into work and that was supposed to be their parenting day and there wasn't a makeup day. You know, I mean, like there's 100 million scenarios where things can just blow up before there's an agreement. So just make sure that you get all scenarios of what your client wants, what they would be willing to give up, what they wouldn't be willing to give up, so that when you get to the negotiation phase with the opposing counsel, you know what your client actually cares about the most, so that you know what you might be able to have some wiggle room on. And finally, you know, make sure that you have that full picture. Say it back to them, basically, because you may think that you have heard what they said, and then you say it back and they're like, that's not at all what I want. You know, they may think that they're telling you clearly, but there's 100 million ways for miscommunication in this. So just make sure by the end of the conversation, they've said what they want to you, you've said it back to them, and everybody's on the same page. Because the worst possible scenario is you going off half-cocked, talking to opposing counsel, making what you think is a great deal, bringing it back to your client, and they're very, very upset with whatever that deal is. So just make sure that you're on the same page before you hang up the phone. So you're gonna, after that call, you're gonna wanna give your client some time to reflect on it. And this is something that, you know, you learn after years of doing this, which is essentially your client will think that they've told you everything that they wanted to say. And then that night they come up with 45 extra things that they wanted to say that they didn't, or they changed their mind about the dates, or they remembered that their kid has a school, you know, holiday program on some date and they need to make sure that they have that date or whatever. There's always some extra thing that in that initial conversation they have forgotten about, and it ends up being the most important thing. It happens with everybody. Things just slip your mind. You're running 100 ways at once. It's the holidays. Give your client that extra 24 hours to remember those things. So you're giving them an email reciting back all of the things that you think that they have said, and giving them a response time so that they can remember those things before you reach out to opposing counsel, so that you, A, don't look foolish when you go to opposing counsel with what you think your client's terms are, and then just kidding, no, they're not. And B, you're giving your client some time to stew, so that later on, if something comes up, you can say, but listen, like I gave you that extra time. I don't know if your demands are really reasonable because you've had some time to think on this. You might have to give this part up. It might not be a reasonable request at this point. That's so that everybody has clear boundaries and expectations for what's going to happen going forward. Which brings us to expectations generally. Obviously, this is your client, you know them the best. So you know what kind of person your client is. It could be that your client is incredibly laid back. They understand that they're not going to get everything they want. They understand that this is a negotiation and that, you know, that's fine. They may be that kind of person. There's also every chance in the world that Christmas is the single most important time of year to them, and they want to be around their family for every single moment of that holiday, and they're unwilling to negotiate any of that time. A lot of people feel that way. It's very difficult to be alone during the holidays, and that's something that you need to couch into the conversation that you have with your client. As you are, the person that knows your client the best, you need to go into the conversation knowing that you're going to have to probably give them some bad news, that there are two parents in this household and that the children will get time with both parents during the holidays. That doesn't mean that they're not going to get any time with their children, but they are going to probably have to make some compromises. And that conversation can be really difficult. It can make the client angry. And there are a lot of ways to kind of ease that blow, namely by focusing on what you want, the biggest goals, and making sure that you get those for your client. If Christmas Day is the most important day, get Christmas Day. If Christmas Eve is the most important day, get Christmas Eve. Make sure that you focus on the most important things in your negotiation and try your best to get that for your client. All the while making sure that your client knows that they can't have everything. And managing those expectations is really, really important, especially before you talk to opposing counsel. Because even though you're obviously going to go in guns blazing when you're talking to opposing counsel, your client needs to know that, the holidays are important for everyone, and everyone wants time with their family during the holidays. You need to talk a lot about compromise and make sure you keep using that word over and over and over again. That way, once you have that first call with opposing counsel or with the opposing party, you can come back and bring that up again. So it won't be a shock to their system that they're going to need to compromise some things. There also needs to be, a lot of our clients have experienced intimate partner violence. There needs to be a very, very sort of intimate talk about if there has been intimate partner violence, the impact that that's going to have on your client. There are a lot of reasons why survivors of intimate partner violence will not want to let their children spend the holidays with their abuser. And all of those reasons are valid. And all of those reasons make sense to, sentient, normal people. But, generally the courts see two-parent households as being more functional households and generally want a fostered loving relationship between, the mother and the children and their father, or the other person, even if there has been violence between the mother and the father. So there needs to be a conversation about that, and there needs to be a conversation about why there's every likelihood that even if this were in front of a court, the judge would most likely still allow the other parent to have parenting time, even given, the nature of any abuse that there was between the two parents. That's not to say that, you need, it's obviously important to validate the fear and concern that your client has, but to stress compromise, to stress all the things that the court stresses, which is a two-parent household, and all those sorts of things. And, the importance of having a father in a child's life. If there are questions or other things that you want to discuss pertaining to your case specifically, always reach out to your Her Justice mentor. We're happy to help with those kinds of conversations and anything sensitive or more difficult and nuanced that needs to be discussed. My favorite quote is from Lynette Rosado, who is a matrimonial judge in the Bronx for a long time, and she was a family court judge and then a matrimonial judge in the Bronx. And she always used to say, in all of her cases, the best settlement is one where neither parent walks away happy, but the children get everything they want. And she tried to rule that way in all of her cases. She was an excellent judge, one of my favorites. And it's true. And that's something that you can tell your clients, that, it's not really about them. It's about the kids and the best interests of the kids, and the kids having their version of the happiest holiday they can. Sometimes when my clients don't get what they want in terms of holiday parenting time, it's something that I tend to fall back on. Pardon me, my lights go off if I'm not moving for more than a few minutes. Artful negotiation. I tend to love this graphic because I think it is the way that I would like to think that my negotiation is. It probably is not, but once you have figured out exactly what it is your client's looking for and you're all on the same page, is when it's time to reach out to opposing counsel, or if the other party is unrepresented, the pro se litigant. When you reach out to them, you need to try and leave as much time as you can. Obviously, this being recorded in mid to late December, you don't have a ton of time, but generally you want to do it as early on in November as you can so that you have as much time to negotiate as possible. Once you contact them, you make it clear that you are reaching out to make sure that both parents, including theirs, get adequate parenting time. I generally like to almost make it seem like I'm doing them a favor in reaching out so that they can take that to their client and say, oh yeah, they're being kind. They want to give you parenting time for the holidays. They could have just been silent. Sometimes that works to your benefit. You tactfully explain your client's position, making it seem as reasonable as you possibly can. Usually it's not, right? I mean, usually your client wants all of the time they can possibly have, right? So you need to, couch it as best you can, making it seem like you are giving them the most time as you possibly can. So, comparing it to how much time they have in their regular visitation schedule, factoring in any domestic violence that there may be, if there's an order of protection, using that. But, making it seem like what you're asking for is a reasonable demand as best you can. If they freak out, which there's every chance that they will, and start to either threaten motion practice or, going to the judge, or they become belittling, which if you are a female attorney, you will understand incredibly well in very short order, then you just restate it. Just say exactly what your client's position is. I don't generally tend to suffer fools. So if they start threatening things, there's no point in going on with that conversation. You can either have a negotiation or you can have like a big baby crying on the other line. Like there's no point in going on with that conversation if they're not actually willing to negotiate with you. Sometimes they'll say, okay, I'll take it to my client, whatever. Sometimes they'll actually want to negotiate it and say, do you think your client would go for another day? Like something like that. Then you just actually negotiate like adults. But I think more times than not, especially if the other party is represented by paid counsel, they drag on a conversation for a really long time because they're billing, right? So just assume that usually the first conversation is not super productive, but don't be waylaid by that. That doesn't mean that the negotiation's over. It just means that's why the dance analogy, that's just the first step in the dance. They'll go back to their client. They'll make it seem like they're, that we're being, very unreasonable or whatever. And ultimately they'll probably just come out with like, in the end, it usually is like another half a day or something. Like it's not a ton that they're going to get, but they have to, bravado to their client to make it seem like they're going to get them the sun, moon, and stars. So just know that first negotiation is not usually that helpful. You also need to go back to your client and say, didn't go great. What are some things that maybe we're willing to concede? You've already had the conversation about what the middling ground is. Now's the time to start talking about, could you do drop off at 6 p.m. instead of the following day? Would that be that big of a deal if you gave him that extra night or whatever? And then hopefully when you come back, you're both closer to the middle. Obviously you're all lawyers, you know how to negotiate, but holiday parenting time is like a special kind of art form wherein while everyone else in the world is feeling incredibly generous and giving, lawyers in family court become monsters for some reason. And so I always want to try and not warn, but just say, just don't show your full hand when you're negotiating parenting time during the holidays, because when you assume people will be in a holiday spirit in family court, they are not. Lawyers will generally not be. And sometimes we'll even try some pretty exciting new things. One note about motion practice during the holidays, there isn't any. Number one threat made by opposing counsel during the holidays, I'm going to file an order to show cause your client's violating the visitation order. Unless the visitation order has a specific holiday provision in it, that will not be an emergency order to show cause. No judge will sign that, especially a week before Christmas. And B, they don't have time to write it. They do not have time to write it and file it. So do not take those threats seriously. I mean, could they do it? Yeah, maybe they will. I mean, I'm not going to say for sure that they won't. I have had it happen twice in the decade that I've been doing this. Both times the judge declined to sign it because no one is dealing with this before Christmas. You're adults. You will have these children for 18 years after we are no longer your attorneys. You're going to have to figure it out. You guys are going to have to figure it out. And I have said that to my clients before. So if your client is being unreasonable, you have to be brave enough to say that to them, just like they need to be able to say that to their client. Once you finally can come to terms, which I believe can happen in every case if everyone is willing to be reasonable, and they may not be, but usually at some point, yes, because everybody wants to have time with their kids. And if you aren't willing to be reasonable, you might just not get any time, right? So usually they're in the unequal position of having to kind of concede some things because they're the non-custodial parent. So in the event that should happen, you draft up a stipulation. You want it to be as specific as you can because you want your client to be able to rely on it and be able to enforce it. Doesn't have to be long, just has to be specific. Make sure you put in pickup and drop off times. Make sure your client's comfortable with the pickup and drop off. If you can avoid it, don't use a police precinct. That's just a personal thing. I think having children being picked up and dropped off at a police precinct on Christmas is, or Hanukkah or Kwanzaa or whatever, whatever holiday we're celebrating, Thanksgiving, is traumatic. And a lot of, the American Psychiatric Association has agreed. So I generally try and avoid it if possible. If it's a real serious domestic violence situation and mom doesn't feel safe, of course, do it there. If you can, do it at a public place instead, just for that one set of pickup and drop offs instead of the precinct. I always try and steer that way if it's possible. If you are doing it that way, though, make sure it's an open place. If it's going to be on Christmas Day, make sure that the Sears or whatever is open because they might be closed because it's Christmas. So negotiation, hopefully you can get a stip drafted in time. That's the ultimate goal. And so with that, we would like to just go through some common scenarios. These are just a couple of things that happen somewhere in the world, at least, once per holiday season.
Caroline, I can't tell if you can see me, but I've unmuted myself, so I'm prepared to discuss these scenarios with you.
Wonderful. Hello, Anna.
Hello.
Okay, so scenario one, the negotiations break down over the course of several weeks on a 12/22, so 3 days till Christmas. There's no final agreement. What do you do?
So for me, I mean, this is always case specific, but one thing I would consider is basically just trying to talk my client at least into have some sort of agreement. And then I might just, especially if my client is the custodial parent, this doesn't work if my client is the non-custodial parent and she's the one asking for the visitation. But if she has the custody and she has control over it, I will try to get her to agree one-sidedly to some sort of schedule that we think is reasonable. And then I will just email it in writing to opposing counsel or to the other parent if they're unrepresented and just say, this is what's going to happen. Please confirm receipt. And then if they don't like it, I guess we'll deal with it. But, it's, in my view, it's a bad idea to say, especially when you're the custodial parent, well, we couldn't agree, so you're not getting any parenting time over the holidays. Because in January, he's filing something and he's going straight to the judge to complain about it, and your client is going to look terrible. So that's a situation really to avoid, is basically doing a power play. And then, especially if the parties are close, but just can't agree about like 1 hour or something, I'll just unilaterally make something up that I, as the attorney, think sounds reasonable and is defensible in hindsight to a judge. And then we'll just send that and say, this is what we're doing. What do you think, Caroline? What do you do?
Yeah, I mean, I totally agree, because I think even where the other party is represented, I think that lawyers use that a lot to be like, if it's not exactly what you want, just reject it. And then after the fact, we'll say she's withholding parenting time, alienation. This is our basis for a change in custody. So I think even just sending it over, I guess my question would be, after you send it over, is the drop off, then does she just drop off the kids if they don't confirm receipt?
No, I mean, you'd have to get some kind of confirmation. I mean, I guess the way I would phrase it would be, we've tried for the past several weeks to reach a resolution. We haven't been able to reach a resolution. My client is prepared to bring the children to X place at 6 p.m. on whatever date. So if I hear back from you, then she'll be there or something like that. But, if I don't hear back from you, or if you reply that you don't agree, that we're not going to do that. But make sure it's in writing so that when they inevitably complain to the judge about it after the holidays, you can at least say that you did your best, in good faith. And especially if you're being the reasonable one in the negotiation, which if you're her justice pro bono attorney, surely you are being the reasonable one, because we're mentoring you to do that. So, basically it's about, at that point, it's about making a written record of you being reasonable and them not being reasonable.
Absolutely. Yep. I think that is the right choice as well. So, hypothetical 2, parties have agreed that dad will drop off the children at noon on Christmas Day. It's 1:15 and your client has called you 16 times. What do you do?
This is a trick question, because at 1:15 on Christmas Day, I'm not answering my work phone. So I'm not doing anything until the next time I'm working, because carving out my own personal time and my own work-life balance and my own family time around the holidays is important to my well-being as an attorney. So that's my first answer. My second answer, I guess, is if the hypothetical is not actually Christmas Day where I happen to celebrate Christmas, like let's say it's a holiday that I don't happen to celebrate and I happen to be working, then, you know, I would probably I would reach out to the other attorney, but counsel the client to have a little patience and try to reach out to other parent herself. You know, he may be caught in traffic or like, you know, something else may be going on. As a last resort, if this is a domestic violence situation where there's a fear that there's actually some kidnapping going on here, or if there is some danger to the children or something is happening that is an emergency, then at that point, it may be worth involving the police, especially if the pro bono attorney has taken your excellent advice, Caroline, and has already drafted the stipulation as a written agreement. Then you can take that written agreement to the police. But if there's no written agreement and it was just a verbal agreement, then the police are powerless to really to enforce anything. So I guess that just goes back to your point in a previous slide about make sure you get it all in writing, because otherwise there's no evidence that 115 is late. What are your thoughts?
I mean, I would totally agree with everything that you said, including if you're not working, you're not working. And I mean, the point of this slide is to say that this should not ever happen. And obviously things are going to come up, but there should have been a discussion with you and your client beforehand about scenarios that could come up. What if he doesn't drop the child off in time? What if this happens? What if this happens? But realistically, if there is a danger, if there's a dangerous situation, that's a police matter. That's not a lawyer situation. If there's an Amber Alert that needs to go out because dad is a danger, there's really nothing that you from, you know, wherever in Connecticut are going to be able to do about that. Like, so my point of this slide is to just say, while your client may be in a panic about something that happens with pickup and drop off, you also matter, your time matters. You obviously need to have the conversation with your client first. If she does panic, she should have a tool chest of things that she knows to do. If dad is a danger, in that tool chest should be call the police, show them the written agreement, and go find her children. If dad is not a danger and he's just kind of an idiot, it should be text him 4 times, make sure that he's not, you know, in an accident or something happened on the way back, then call the police, make sure everyone's okay, you know. But really, none of those are legal problems. Those are either police issues or he's just caught in traffic. So,
Right.
the
I mean,
point of this,
if he is just trying to be, you know, manipulative and it's not a police emergency matter and it's not a lawyer matter, then I guess the other thing to tell a client is to make a written record of it. So to make sure that she has the conversations with him via text or email so that you can go in after the holidays and complain about how he didn't respect the agreement. And, you know, that means that he loses parenting time, but you can't do that unless you have it all down in writing.
yep. Yes. Next up is parties have an agreement regarding parenting time memorialized in writing. Parties have an altercation on 12/23 and your client decides not to send the children and does not tell you. Opposing counsel calls you on Christmas Eve stating the same. What do you do?
Is this another trick question where the answer is this isn't going to happen because you're going to have perfectly counseled your client ahead of time that she is to follow to the letter the terms of the written agreement? Because if so, kudos. But then again, like we all live in the real world, and you're going to counsel your client so carefully that like, hey, this is the agreement. This is what it means. You understand it. We're putting it in writing. That means it's enforceable. If you don't follow this agreement, you're going to get in trouble and the judge is going to be mad at you and you're going to look really bad and it could affect your case. And you're going to have all those discussions and then this is going to happen anyway. Assuming you are reachable on 12/24, going back to my prior point about like, if this is a special family holiday for you, then you are not obliged to pick up the phone. because you have counseled your client and she didn't follow your advice. And again, that's not necessarily like a matter that means that you have to give up your own time. But if you do pick up the phone and talk to opposing counsel, then the best you can do is say, I advise my client to follow the stipulation. I will reach out to her and try to find out what is going on, and I will get back to you. And then do that and reach out and try to find out what is going on and then get back to opposing counsel. But ultimately, you were not her babysitter. And if you gave her all the advice that you were supposed to give her and she's choosing not to follow it, then she may have to live with whatever consequences come. Now, if there's an emergency and she didn't release the children because the altercation on 12/23 was like a terrible physically violent thing and she's afraid of him and she doesn't want to give the children because he's threatened, like, the next time I see you, I'm killing all of you, that's a different thing. And, if you find that out, then obviously that's what you're telling the judge in January when they inevitably bring the motion for contempt. So of course, don't advise your client to put herself or her children in danger if she has a good faith reason to believe that there's danger. But if this is out of spite, or they had a fight about something that she's displeased with his new partner or whatever it is, those are not reasons to not abide by an agreement that you negotiated and put in writing. So I guess, this is a tough one, and we've all had these. And ultimately what I tell all the attorneys that I mentor is, like, as long as you feel good that you gave the client the advice that she needed to have, and that conversation happened before this, then you can't control her. She's going to do what she's going to do. And if she's going to sabotage the case, then you deal with it after the fact. But then, she's got to understand that actions have consequences too, and that she may get a result in the overarching custody case that she doesn't like. I don't know if you have any less stern thoughts.
No, that's exactly correct. That's the hard and fast truth. Like, you can prepare for just about anything, and you can counsel your client, and you can go through everything. And, all of this whole, time that I've been talking is to say, make sure you're prepared, make sure you're prepared. But you could be prepared for everything under the sun except for your client's free will. And she's going to do whatever she wants. In the end, she's going to make her own choices, and you cannot prepare for that. So there is a point where you have to let her make her own choices. And I think for a lot of lawyers, that's really hard, because what the outcome's going to be, and that's all you can do. So
Yeah.
I guess that's just to say, if your entire Christmas Eve, and I've had this be my life before, where your entire Christmas Eve is trying to convince someone on the phone to let the children go to dad's because there's a written agreement that says they should, and you've lost your entire holiday for it. Don't do that. Just don't. If that's what she's going to do, that's what she's going to do. And that's
Right.
not even a legal argument that you're making to her. That's just being like, you're only hurting yourself, like that.
Yeah.
You're not lawyering her anymore. You're trying to cajole
I
her
mean,
into doing the right thing.
yeah, you can have that one conversation on Christmas Eve, call her up, and if she picks up, assuming she picks up, say, hey, what are you doing? Don't you remember we talked about, you agreed to give dad the kids at this time, and remember I said that if you don't follow the agreement, it could look bad for you. But like, have that conversation once and then hang up the phone and go about your day, because there's nothing you as a lawyer can do about it. And I know this is something that lawyers can struggle with when they don't do family law as their specialty, because I think in many other specializations, you're used to more corporate clients who, not always, but generally can be relied upon to do the
To do what
things
you
that
tell them.
right. Especially if they're paying, $700 an hour for your time or whatever, like, they're probably going to value your advice. And so it can be a little bit of a shock to come into a situation and then feel on the hook, because clearly as lawyers, we have ethical obligations. We not only ethically need to say what we mean and live up to our promises, but we also want to be viewed as being reliable and trustworthy, because our reputation means everything. And so it can be really upsetting when we have made a representation to another attorney or to the court saying, my client will do this, and then she doesn't do it. But at the same time, even though you might not be used to that, the family court judge, you can bet, is used to that. And the opposing counsel, they might huff and puff, and they might yell at you, and they might take it all out on you. You just grin and bear it, because at the end of the day, everybody understands that it's not, if you can say, I advise my client what this settlement means and what the consequences would be to her of not following it, and I made that very clear to my client, and if you can just say that, everyone knows. Like, that's all you can do as a lawyer. It's not like anyone's filing a grievance against you with the bar committee. Like, it feels icky as an ethical lawyer to be in that position. And, maybe you want to have a serious talk with your client after the fact and say, can I still represent you if I can't rely on you, to follow my advice or to stick with these agreements? And you may have to have that difficult conversation, but in the moment, it's okay to just live with that feeling that, like, everyone's mad at you, but they're not really mad at you. They're mad at your client, and everyone understands that you're just kind of the punching bag. And sometimes your job as an attorney in family court is to be the punching bag. And, like, that just is what it is. To put it bluntly.
Yeah.
I don't know. Any other thoughts on that, Caroline?
Well, and I mean, that's why you're there, right? Is like so that
Mhm.
you get punched and your client doesn't. Like that's why we get paid the big bucks. And so that our clients don't have to take the brunt of it, because
Yeah.
they can't.
But in this situation, there definitely needs to be a very serious conversation after this urgent issue and after the holidays, and just being like, hey, what happened back there? Our attorney-client relationship and my ability to represent you depends on me having trust that you're going to follow through on your agreements. And if you don't trust my advice, and if I can't trust that you're going to do what you say, then we can't go forward like this. So what's going to happen? So that has to, talk to your mentor about that after the holidays. But that's something to think about.
Absolutely. So that is my last hypothetical.
I will drop back
I have.
out.
Thank
Thanks,
you so
Caroline,
much
for
your
letting me
input.
join in. That was fun. I'm going to drop back out
I
of video.
appreciate it. So this year, obviously, everyone knows and everyone's heard 100 million times that we all have to pivot to meet the growing concerns of the COVID-19 pandemic, but especially for trying to figure out parenting time. Really, doing any family court stuff, as you all know, is almost impossible because A, the family court isn't doing anything, and so clients are pretty much on their own to figure it out. But B, just like everybody living in normal life, parents are totally reacting differently to the pandemic. I mean, like, some parents are out and about doing whatever they want. Some parents are totally quarantined. Some parents are sending their kids to school. Some parents don't want to. And just like they didn't, their relationship didn't last as parents, as a couple, their parenting styles are wildly divergent as well, which makes pretty much everything about co-parenting much, much more difficult, because the pandemic makes life generally difficult, and then trying to figure out a baseline for we both have to do this exactly the same way, because there needs to be a baseline for this family, because if one parent is taking all these risks and the other parent is taking none, then the children aren't gonna have any sense of what their level of safety is, and also the parent that is the safer parent is going to go insane, right? So with parenting time during the holidays, a lot of things that we normally don't have to think about now need to be taken into consideration, especially in the drafting of that stipulation. So those considerations include travel. We would hope that everyone living in New York City would be smart enough to not, end of sentence. But, you know, Thanksgiving, there was a big uptick in New York after. So a lot of people did travel. A lot of people went to see family. We assume a lot of people will go see family again for Christmas and Hanukkah and, you know, whatever holidays. Like people are traveling. So that needs to be discussed, um, especially because, you know, if you say you have parenting time from X date to X date and you don't address whether or not the parents are going to be traveling, they could just travel because there is no, you know, I mean, there's nothing that says you have to, generally, you wouldn't need to say, like, I'm going to be going to X state to stay with blah people. You know what I mean? Like in normal times, you wouldn't need to say those kinds of things because it's none of your business. Um, you could say, you know, if you're traveling out of state, you want, you know, addresses, a check-in time for the call, whatever. Um, but now, even if you're going to Jersey, you're going to want that in the agreement because the other parent needs to know who you're going to be with and where in New Jersey you're going to be and how many people are going to be there and all those kinds of things. So that also needs to be in the agreement. If someone's traveling from out of state to be in New York for that person's parenting time, that needs to be in the agreement. Pretty much everything needs to be in the agreement so that both parents have all the information. And so all that stuff can be hammered out before. Because worst case scenario, kids come home, we saw Aunt Debbie or whatever, she's from Florida. Like no one needs that right now. Then everybody has to get tested. We all have to quarantine, this, that, and the other. I had to take a couple weeks off of work because you did blah blah during your parenting time. Like it's gonna blow up. And I'm sure it will. I mean, it did over Thanksgiving in my in-house cases. I'm sure that, you know, it happened. There was a lot going on in family court after Thanksgiving. I'm sure there will be more. So the more information, the better. If you can detail, you know, even down to like the names, if you want to put them in the agreement of who's going to be there so that everyone's on the same page. We know who's going to be there. We know how many people are going to be there. We know how long we're going to be there. We know where it's going to be. If we're all having dinner together, how long are we going to be at that place? How are we getting there? Are we taking MTA? Are we driving? Are we concerned about public transit? Does one parent have a concern about public transit? The other one doesn't. Like, just all of those nuanced little things that we think about because we live here and we think about for ourselves. Now you have to think about not only another person, but the children and possibly extended family. So, you know, the things that you're doing in your own lives as lawyers and just as people, think about that for your client and then think about, you know, that bubble, that pod and how far it's extending. Try and keep it small. You know, I mean, my advice to all my clients has been, do you need them there? Does it have to be this year? Can you put it off? You know, there's a vaccine. It's not going to be that long now. Can we wait another couple of months? You've held on this long. You know, the same kind of things that I keep telling to myself when I'm going to sleep. Tell your clients that. Like, would it be easier to write this agreement if you cut out blah blah coming from North Carolina? If you, would it be easier? Would you be more accepting of the agreement if you said grandma wasn't coming? You know, those kinds of things will make the negotiation easier, but also will keep your clients safer and their children. So, and maybe that's just me being, you know, having lived in New York City through this pandemic, but I think it's probably best and safest for everybody to keep things small and simple. And in my experience with getting the negotiations done, it's made things much faster and streamlined. So those are COVID specific things that you want to make sure you're addressing both in all the way from your initial call with your client to what are they doing. Make sure they're forthcoming with you. You be forthcoming with opposing counsel. Honesty is the key here because, as I said, you don't want all these things to come out after the fact and have your client be the one that had a surprise guest from Texas, you know. So make sure you talk about pick up and drop off. Is it at a precinct? Who is the place open? You know, all those things that we talked about. Try and plan for those things ahead of time and be able to put them into the agreement. Make sure if you're having overnight visitation, you know who's also staying there. If you're having out of town guests, are they staying there overnight? Are you now going to be in a room with somebody who's coming from out of town? All of those kind of things need to be written into that agreement. Write as much as you can in there. The more information, the better, as always. So that is it for me today. I so appreciate you taking the time to watch this, and I hope that it was helpful in helping you prepare for your specific cases. As always, if you have specific questions about your parenting time schedule, you can always reach out. Just know, as we discussed, that we're all just people. We're all trying to have some rest and relaxation for our holidays as well. So be cognizant of our time, as we hope your clients will be cognizant of yours. And I hope that everybody has a very safe and restful holiday season. Thanks so much.